Welcome, everyone. Good evening. I'm so glad for you to be here with us tonight. Let us kick off the event, and as people arrive, they can join us. So tonight we are happy to host you at our next online event. This is a launch event for the newest 4.2 issue of Interactive Entertainment Law Review. And this is a special issue, really close to our hearts. Let me tell you why. So first of all, the event is called Breaking a New Frontier. We are watching as games, this form of entertainment and social networks with really immersive and compelling gameplay mechanics and technologies are becoming the very center of the new economy, of the new way of interacting and socializing. We are seeing gamification take over fitness, health, education, and other sectors. And in our latest issue, we were really fortunate to be able to feature articles that all explore a particularly innovative aspect of video games as products, as service, and the industry as a whole. Whether it is looking at augmented reality and virtual reality as a new type of medium, as a new type of expression, and how that may be protected by intellectual property rights. Whether it is looking at new types of practices such as deceptive advertising and gambling that is included in the interaction between influencers and their audiences, or looking at site blocking measures to tackle copyright infringement of video games in Russia. They all explore and highlight potential discrepancy between existing laws and regulations and how these may apply. And if you remember, in our previous event, we looked at the advanced access article on design intelligence. All these articles look at how the law often lacks or is not fit to interactive entertainment specifically, because when it was drafted and introduced, video games were not really considered as a special case, that specific features or needs of users may not have been thought about carefully. And therefore, this gap between reality and the laws and regulations that they apply creates specific difficulties and legal uncertainty. In addition to that, all the authors that are here today are alumni of the Interactive Entertainment Law module, or at least some aspects of it as a sort of singular lectures. And they are all women on a successful trajectory in their careers to hopefully make a positive impact on the video game industry. So in a way, this is also sort of culmination and celebration of work we do at CCLS, trying to establish a truly diverse and inclusive scholarship on interactive entertainment law as a standalone discipline through our teaching, research, and outreach activities. And I'm so glad to welcome here today our speakers, which are, in no particular order, Olivia Jean-Baptiste, that studied IP law at CCLS, graduated in 2020. She has since worked as rights assistant at IMG, Evoke Films, and she continues to write on topics related to art and intellectual property. And this month, she is starting her studies towards legal practice course at BPP University. Next, we have Zoi Potolia, also a CCLS alumnus. She took the Interactive Entertainment Law module. She has keen research interest in regulation of new media and video games, the industry as a whole. And her research specifically focuses on sensitive topics like exposure of players to gambling through gaming. Her article in the latest issue particularly looks at how influencers employ methods of deceptive advertising to promote gamified gambling to their audiences. She has experience in IP advisory, dealing with IP disputes and brand protection matters, specifically within trademark law. We also have Alena Kuzmina here tonight with us, who is a senior legal counsel at Moscow-based intellectual property law firm, Semenov&Pevzner. She studied LLM in IP and IT law and Higher School of Economics in Moscow. And that's where she met Gaetano, who was a visiting professor there, having lectures on interactive entertainment law. She specializes in all facets of content and brand protection, anti-piracy, and copyright disputes. So welcome, everyone, and thank you for coming. Alena, I would like to start with asking you about the topic or issue of copyright infringement of video games and how site blocking is used in particular to tackle this. First of all, I just wondered how rife copyright infringement of video games is in Russia, and whether it specifically differs from any other digital content. And also in the context of the recent pandemic, whether you've seen a huge jump in piracy practices when it comes to video games. Thank you. The floor is yours.
Thank you, Michaela. Thank you very much for the opportunity to be a speaker today. It's a really interesting question you've asked. Well, in Russia, generally speaking, copyright infringement, regardless of the industry, whether that's the video game, the motion picture, the publishing industry, it's a persistent problem. And I've been involved in the anti-piracy industry for almost 7 years now. I think I've started working back at my previous IT firm, who actually tried to develop the first rules of the anti-piracy law, which are now implemented. And we were basically the pioneers with our major clients, such as the Hollywood studios and the interactive entertainment publishing companies. We were the pioneers to, firstly to address and apply the site blocking law as it was adopted back in 2015. And I observed the emergence of this law. I observed all of the issues that the rights holders faced back then. We tried, to lobby a couple of amendments, in order to improve the law a little bit. Some of them were adopted, some of them weren't, unfortunately. But we're always trying to communicate with the industry, always trying to communicate with the legislative authorities, to somehow develop this particular law. But the thing is that Russia, unfortunately for now, remains a thriving market for many legal resources, and these resources, they severely damage the market for legitimate content consumption. And the interactive entertainment industry, the video games, is not an exception here. I think that during the pandemic, especially, the illegal content consumption, especially in Russia, has increased rapidly and dramatically. And another problem is that due to the very hostile piracy environment, Russia remains in, many of you know that Russia remains in regular notorious market lists, which are yearly published, such as the Special 301 review published by the US government, and the notorious market list. And there are thousands of resources either hosted or operated, administered from Russia that are placed into this list, and they severely damage the market at the moment. So most infringing torrent indexes sites, most infringing illegal streaming websites, which distribute the illegal files, illegal copies of the video games. They also distribute and promote the cheating software, the hacks, the bots, the pirate modifications, or even other unauthorized digital content or digital goods. So this is like a persistent problem here, and the Russian anti-piracy law somehow try to solve this problem at the moment, and partially it did. So the site blocking as it is right now, this whole process and the results that we're seeing, they are improving yearly. So the thing is that, right holders, we're trying to bring more and more right holders to address and apply the site blocking law against the most infringing and notorious and non-compliant pirate websites, which are available in Russia or hosted from Russia. And we already tried to and successfully blocked and shut down a huge and enormous projects, the pirate projects that were thriving here in Russia. But the problem that I'm also addressing in my article is that not only sometimes the whole site blocking process in Russia creates burdens for right holders to gain a court decision as fast and as they can, and block the website in order to prevent the illegal content distribution as soon as possible. But also another problem is that whilst the for instance, motion picture right holders, they're trying to apply this law and address this law for many years now, and they successfully do that. I think that with the motion picture industry, we have blocked more than 1,000 pirate websites here in Russia, when unfortunately the interactive entertainment industry and video game developers are not so eager to come into the Russian market yet, and try to do some apply some remedies of copyright protection here. And what we're trying to do now is we're trying to encourage many of the video game right holders to access the Russian market and to try to use this law, the tools of this law, in order to create some landmark decisions, as the Russian case law at the moment really lacks the decisions and judgments from the interactive entertainment industry. I'm not saying that this is an uncharted territory for the Russian judges, no, and no more, at least for now. But as of now, many of the especially regional Russian courts, they still have this judgment that the video game industry is not something that you can actually enforce in Russia. There is an exception in the Russian civil law, in the civil code in particular, that the gambling industry cannot be enforced and protected in court. So some of the Russian courts somehow apply these gambling regulations into the video games because they think that video game is basically the same as gambling, and thus it cannot be protected from the legal perspective. So it cannot be awarded any copyright protection, any patent or trademark protection, and this is a prejudice that unfortunately still presides in some of the Russian courts. The Moscow and the St. Petersburg courts are more progressive here, but what happens in the regional courts is a disaster. And this is why we're trying to encourage the video game right holders to try to develop the case law here more and more. And the Russian anti-piracy law is actually a very good mechanism to do that in the first place. Basically, the costs are nothing to in order to initiate a case under the cyber-blocking and anti-piracy law, and the process is quite straightforward and simple. And in comparison to what I know is happening in the European Union courts, it's even faster and quicker process than in other countries. So I guess that I'll be willing to share the presentation about the cyber blocking and explain how it actually works. So if I need to do that now, please let me know.
Let's do that. I did have a follow-up question on what you said. It does sound as if the law itself, the legislation, wasn't, when it was being drafted, video games weren't really considered as a special case that needs to be taken into consideration, something that perhaps has specific features or characteristics that need to be reflected. But it does sound that the nature of the legislation means that it's quite flexible, and perhaps the simplicity of the procedures enable rights holders in different kind of or rights holders of different kind of digital content, different kinds of works, to be able to apply the law regardless of whether this is a case of music, movies, or video games. So I did sense that there are certain limitations of why perhaps the law itself hasn't boosted protection when it comes to the video game industry. But it sounds that a lot of that has to do with the perception of the legal nature, or even nature of video games in general, and perhaps legal nature of video games specifically. Do you think that is the only limitation of the law when it comes to protecting video games from piracy, or are there other specific aspects of how the legislation was drafted and implemented that discourages or disadvantages the video game industry as a whole?
So of course, every law in every country is drafted in according to the interest and needs of the party who lobbies it, and I think that's pretty common knowledge. So the lobbying industry of the anti-piracy law was the motion picture, and obviously it attracts the motion picture clients, of course, in order to be addressed and apply here. But the video games under the Russian law, they're mostly treated as software. If we're talking from the legal perspective, then the video game is basically a software here. So it's also a common term applied even by some of the courts. And we have some recent landmark cases which specifically address the video game as the software, as a code, as a source code. However, of course, the recent academic papers, they treat the video games as a complex object rather than just the software, because software is nothing but a part of the video game. It cannot be treated like that one, just a simple source code. Video game includes the scenario, the images, the music. So we, in Russian law, in Russian civil law, we have a separate complex object concept, which includes various objects in general that can be, it's like a motion picture, basically, an audiovisual work, if I may say, and it's actually treated like that. So, and it should be treated like that. But at this moment, the courts are not willing to do that, which is why, you know, the issues that we need landmark decisions in order, you know, to develop this issue and to get rid of this issue. But, you know, to sum up, the video games, of course, they are included into the anti-piracy law and site blocking law as a software because they treat it as such. However, of course, the interests of the video game right holders were not affected when the law was initially developed and drafted.
If you would like to perhaps briefly describe the site blocking procedure and how it's being applied
Sure.
In your...
Yeah, I'll just share the screen, just a moment. So I have like a very brief presentation of how everything works, and it's, well, quite simple and straightforward, though the issue with the whole blocking law is that is a twofold process. In order to block the website permanently, basically for a lifetime, forever, you need to have strictly 2 court decisions, and this is one of the features that distinguishes the law from the European style site blocking. So the first, just a sec, yeah. So the first stages is called the title specific injunction. So you as a right holder, for instance, you detect an infringing copy of your video game published on a torrent indexing website, and you would like to remove it. However, you send the takedown notice. However, the website operator or the hosting provider does not respond, or just, you know, remains totally non-compliant. And here's what you can do. You can file an injunction into the Moscow City Court. That's the court of the exclusive jurisdiction to hear the cases which involve site blocking, anti-piracy, and general content protection. So you file the title-specific injunctions, and within 1 or 2 days, the court issues the preliminary injunction, based on which you can then file the basic statement of claim, and then just a sec, I'll skip to the next part. And then the court issues the final judgment, the first judgment, which is called title specific injunctions. During this period, the content is removed under the court order, but by virtue of Roskomnadzor. Roskomnadzor is an administrative body which implements the court judgment here. So the problem is that Russia is, you know, it's very large, and it has many ISPs, which, you know, cannot. It would be very inconvenient to file a statement of claim and state a defendant at each and every ISP that we have all over Russia. It would be 1,000 of defendants. You will be bankrupt when you will have to pay the state duty based on how many defendants you've got there. So, which is why the law just states that you can file that against the website operator if identified, of course, or you can do that against the hosting provider, which can usually be, identified via the just WHOIS database. And that's when Roskomnadzor comes and helps to implement the order. Basically, what they're doing is that they are also sending the notice to the website administrator and hosting provider, requesting them to remove the content. Otherwise, the website will be blocked temporarily unless the final decision is issued. So if after the 3 days, the website does not remove the infringing content, then the website will be temporarily blocked. After that, we come to the second stage when the decision is issued. The second stage is the permanent site blocking. So the permanent site blocking is up to the right holder to address and apply, of course. But if the right holder sees that the website still has infringing content available, and if the website still remains non-compliant, or it has tons of the other illegal video games available, then the right holder may file another injunction under which the court can basically issue the permanent site blocking order. And this is when the site can be blocked for a lifetime. Overall, it takes up to 6 months for the website to be totally shut down. And here is when the problem arises. And this is what I'm trying to highlight in my publication, is that in comparison with the European style site blocking procedure, the Russian one remains very, very formal, because you cannot receive a dynamic site blocking order. The thing is that all of the orders that Russian courts are issuing, they are domain name specific. So, for instance, if you have the domain name XYZ and after you receive the decision, of course, there are many circumvention tools to bypass the site blocking, whether that's VPN, whether that's the mirror sites, the proxies, and so on. This is the pirates, they're very creative, and this is when they step up, and they're always trying to find circumvention ways. So the thing is that all of the mirror sites and all of the proxies cannot be applied, cannot be blocked under this court decision unless you receive the second one. So just in order to block all of the reappearing mirror sites of the infringing website of the pirate site, the one decision is not enough for that, and this is a major gap in the law, and the courts are not willing to change it, unfortunately, because they always need to see the consistent and systematic copyright infringement, and in order to prove that, you need to have 2 decisions rather than 1. We have been, trying to change their opinions here, where we've been trying to prove otherwise, that the pirate site is a very huge, it's very popular, it's infamous, it has tons of illegal content, and we are not the only right holders, we're not the only claimants whose rights are violated here, but they are not trying to listen. They follow the strict approach of the law, and they need 2 decisions in order to block the reappearing mirror sites. So unfortunately, the problem still remains, and we cannot do anything at the moment. That's why I'm trying to popularize it a little bit.
I am hoping that your publication and also tonight's discussion will be yet another step in that process. Thank you so much for the insights and sort of detailed walkthrough of the anti-piracy legislation. I know that you may need to leave us a little bit early, and if that's the case, thank you so much for being here tonight and for joining us and sharing your expertise and experience from the field. This is much appreciated. If you can stay, then please do, but if you have to go, yeah, that's absolutely fine.
Thank you very much.
Thank you so much. Thank you. I'm going to now move on to Olivia and Zoe. Olivia, if I may ask you the next question. Your article is on augmented reality and virtual reality art as a new form of sort of artistic medium, new form of artistic expression. At the time where especially virtual reality is going sort of becoming mass market, what do you think that specifically distinguishes this new medium from the existing forms of art, and what legal challenges does it bring with itself?
Well, I think the sort of the vast technological advancements that we've seen, I mean, even since I've written that article, show that the development of art in the virtual space is very, very, very rapid. I mean, since then, we have the metaverse and NFTs that have come in. I mean, Sotheby's even has its own digital auction within the metaverse. So I think the digital space has really offered new challenges, particularly with augmented reality art, where the virtual art and the digital art is meeting the real world. That's where the novel challenges arise, because we have no real case studies or any sort of background on where the line is drawn, whose rights will supersede whose. I think that's really interesting part of that.
So if we're looking at augmented reality and virtual reality, they're obviously different kinds of technologies, expressions, different formats. Are they different only in theory, or are there real differences in practice as well that they have then legal implications when we're looking at securing rights in AR, VR medium?
Virtual reality is more the enclosed space. I think the example I have in the article is of a virtual reality experience by Mika Johnson, where you wake up in this room and you wake up as the creature from Kafka's Metamorphosis. And that's the sort of artistic experience that you can hear the sounds that you've transformed into this being and all these things like that. So virtual reality is more that enclosed experience where you're within the digital space. Augmented reality or mixed reality, you're interacting with perhaps a digital overlay that you're seeing in the live environment. So there, particularly with the live environment, you might be considering freedom of panorama, issues like that, versus within an enclosed environment like virtual reality, it's more the traditional staples of copyright and how you're going to protect an art form that's inherently vulnerable because you're interacting so in depth with the environment around you.
Okay, thank you. Zoe, in Olivia's article, what she's talking about is sort of driven by innovation and creativity, introducing new forms of expressions and new layer and level of immersion. Your focus is on emerging social practices when it comes to influencers interacting with their audiences. What is driving this particular trend and this particular phenomenon? Why do you think that we are seeing examples of deceptive advertising and forms of gambling? What do you think is the driving force there?
I think with influencers, there's always a main drive, of course, to have influence, to become known. This is the only way you can succeed in platforms, in new media, so you can grow your audience, hence grow your revenue. But I think quite like in the recent years, the trend has become that, you know, in order to maintain or even grow a successful channel on new media, that is YouTube or Twitch, it needs a lot of work. So, and the more this community grows, and you know, the share of available ad revenue for creators diminishes. So oftentimes a creator may look for supplemental ad revenue through endorsements and affiliations, and that's when it becomes tricky, because what I talk about a lot in my articles, how influencer success is highly attributed to the kind of relationship they have with their audience. And this is a kind of relationship that's based on trust. And that's when it's very different to commercial methods of advertising, where you can clearly see the commercial intent when you have an ad on TV, for example. Whereas when you watch a content creator, and case being that you might be watching someone for years, this is a different kind of relationship. So when they recommend something to you, you trust their opinion more. But I think that it has become a highly competitive industry, even between them, in order to gain success, gain fame, ultimately monetarily benefit from this. And that's why sometimes they have to compromise ethically.
Okay, thank you. In terms of the most immediate legal tool or legal mechanism to address this emerging trend, that would be consumer protection laws as a sort of first go-to legal remedy. Do you think that the current legal framework is fit to deal with this issue alone, or do you think that there are gaps that need to be addressed in order to identify and obviously eradicate practices like that, especially if we thinking about a very diverse digital audience where not everybody is aware that this is a case of deceptive advertising, or this is a case of gambling and so forth?
Yeah, so firstly, let's mention the framework that is already in place right now for influencers. So for example, we have the FTC in the US, and what they've done is that they've revised some endorsement guides regarding advertising practices, and their guidelines are quite wide. And there is a question here on whether this is on purpose or not, because even though the guides include quite detailed scenarios of how an influencer can disclose their endorsement, they're quite open to interpretation. And because the guides were revised on 2009, there is a line of thought that this is on purpose, so the guides can be adapted to new emerging platforms and media and stuff. However, the real problem is that the FTC lacks in taking action when it comes to, you know, influencers and scandals and not properly disclosed endorsements. And what is explored in my article is, of course, one of the biggest sagas of undisclosed endorsements, that it was about CSGO gambling, very famous YouTubers playing on Twitch. But also their case was the first FTC action complaint against individual influencers. But what's really striking, it's even though this caused a lot of stir and a lot of controversy when it happened, they didn't get a real punishment in the end. and everything is now back to normal. And it's interesting to look at those influencers nowadays, the ones that were involved, and everyone has forgotten about it. So I think what the law in this field really lacks right now is actual enforcement, because it's quite wide, and the FTC should be exercising its authority more. And not only FTC, all the relevant regulatory bodies, I think, should take action.
Thank you. Olivia, thinking about your focus, do you think that the current legal framework is ready for AR, VR in terms of ensuring that creators are able to benefit from their work, they're able to commercialize it, and so forth?
There are certainly glaring gaps in protection. I think there is an advantage to some extent for having a piecemeal approach for virtual reality, since it reflects the way that the art form is created. There might be different people working on the code. There might be one artistic director that's focusing on that visual product. So there is some benefit to that, but we see with statutes such as the UKA, CDPA, if we look to protecting the artist's right of integrity, we can find that the definition of treatment under the UK current law does not really include any digital editions. So the nature of a digital edition from an augmented reality artwork might not have any bearing on the artist of maybe a physical work that has had an unauthorized digital edition put there to make any claim, since it wouldn't be deemed as real derogatory treatment. I think that's sort of a glaring issue that will, as this art form becomes more popular and people might be using it to be controversial or completely change an artist's original message or statement, especially if it's social, political, it's quite a glaring gap to have, to not be able to protect your artwork in that way. I don't think that's really beneficial to either the artist's physical works or digital works.
Are there any differences between approaches in jurisdictions such as UK, EU, and US? And of course, looking at it from the perspective of a future opportunity, given that UK has left EU, and there may be potential of setting on a slightly different trajectory when it comes to copyright protection. Is there perhaps a jurisdiction UK could learn from in terms of wider or more robust protection for this type of media?
I think what I found in sort of analysing the issues in the article is that there's no true safe haven for digital artworks. And even between virtual reality and augmented reality, they each have different needs that can pull at each other. I think an interesting part to look at was in France and the UK, obviously in terms of software, there's no real moral right for integrity that's really enforced there. I think something that could maybe protect sort of the gap that's left could be, trade secrets rather. So there's been cases previously concerning Oculus about how code was used in a different software. I think if we're going to be protecting digital artworks in those two spheres of both the visual display and the technological part, I think there could be room for that to be working alongside copyright law.
Okay, thank you very much. Zoe, thinking about what you said about the current state of affairs when thinking about influencers, their practices, the response of regulatory bodies, do you think there was a sort of missed opportunity for self-regulation? Could the platforms or even the influencers themselves, in some rare form of coming together and finding a common interest that would be to the benefit of their audiences, could have they done something to minimize these practices, deceptive advertising and potentially gambling?
I think the most common opinion that circulates around this is that self-regulation is, perhaps it's too late for that. But I think it's interesting to see now that many influencers, even though they properly disclose their endorsements and, comply with what they should be complying, then go on by saying, for example, oh, even though this is affiliated or I'm sponsored by this company, this is my honest, genuine opinion. And this is a bit of a loophole sometimes, especially when it comes to the relationship, again, they try to maintain with their audience. It's because, for example, the FTC says that an influencer is not going to be under review with the endorsement guides if they state that they state their honest, genuine opinion about something. So what happens when someone is sponsored and endorsed, but at the same time they say that this would be their opinion regardless of an endorsement? So it becomes a bit tricky to discern what's genuine and what's not, especially when we're talking about audiences where it's completely targeted to mostly minors or teenagers. Even me as an adult, I consume content, and sometimes I've been watching people for years, and it has happened to me that I will see someone stating this and I will have a self-doubt as to, was this true? Is this really genuine? But I think also the burden shouldn't be only on influencers themselves, because they have a motive and they want to succeed. So it would be interesting to see, and I think there really is a missed opportunity, and it's interesting to question whether this is, again, on purpose or not, from new media platforms to introduce regulatory measures and practices. Because, for example, you have Google, who has developed advanced algorithms on YouTube that they are about to increase viewer engagement or detect copyright infringement. And you see that YouTube even has an entire self-regulatory model about channel strikes, or they take down videos for copyright infringement almost immediately after someone uploads a video and they contain just a sample of music. But it begs someone to wonder, couldn't there be an algorithm developed to potentially detect harmful content, especially when it comes to gambling connected to minors and connected to gaming?
I think in that sense, the most controversial point in that will be the definition of gambling itself, and what does it mean, and what are the circumstances in which something qualifies as gambling. And that in itself will be jurisdiction specific, which doesn't mean that platforms can be looking for a technological solution. But I think initially this is a theoretical and an ideological issue that needs to be discussed first with multiple stakeholders. What kind of business models, underlying business models and microtransactions we deem acceptable, and also depending on the audience, and which are not acceptable. And I think the point of transparency that you've raised is really important, because if we know what we're dealing with, then it's much easier to think about possible solutions, some of which may have form of technological solution. I've got a couple of questions from our participants tonight that registered these questions before the start of the event. So I'm going to go to them if that's okay, because I think they sort of fit well with what we've just been talking about. I've got a question for Olivia, and that is, what is the future of AR and VR on mobile games? Do you think that this particular ecosystem of casual games on mobile devices is slightly different. Again, in terms of sort of uptake of the technology itself and any sort of legal implications.
I think that mobile applications being so accessible only sort of increase the urgency for the law to keep up with these movements, particularly when we're looking at AR art. A lot of that will be either accessed by your mobile phone or be created by your mobile phone. And there's already been, the art I mentioned in my article by Amir Baradan that was accessed by placing your phone over the Mona Lisa in the Louvre. And I think he has other artworks that you can place in different areas around Italy. So I think that really only just increases the urgency for us to keep up with it. VR and digital art, they're all about participation and how people can get involved. So by their nature, they're going to be raising these novel issues.
Thank you. I think it just further brings home the underlying theme or phenomenon of this generation of players that really want to express themselves, whether it's through streaming or modding the content, building their own content, building their own games, engaging with new mediums to sort of create a different dimension to the whole experience. And the whole industry, the whole interactive entertainment industry is evolving based on this innovation and drive innovation and creativity, including the underlying business models. So from premium to freemium models, we are now seeing models that are based on sort of earning based on the content that you create, the engagement and the creativity that you put in. So there's a whole new generation of creators being empowered to use video games as a vehicle for to make a living, to make a whole sort of way of sustaining your life. Based on that, Zoe, do you think that looking at the existing business models and various microtransactions that influencers either promoting or being involved themselves in, can a sort of balance be maintained between the influencers that obviously want to earn a living doing this, and the audience that is consuming this content, and the platforms and video games providers that also commercially benefit from this additional advertising? So that was the next question. How can we ensure that we keep a sort of healthy balance between these different interests as the video game industry is transforming and the business models are adapting really quickly to this transformation?
I wish I could be a bit more optimistic about this, but I think a balance between that, I'm not so optimistic that we're going to see it just happening by itself. I really do think that regulation is essential, especially when we see, again, even from the time I wrote the article, things have changed and dramatically. We see new business models such as NFTs being used for games, and that's a really big problem because, for example, with NFTs and the cryptocurrency, it's a completely unregulated and anonymous industry, and the way it operates leaves many like open doors for opportunities to be further misleading in statements and further taking advantage of your audience, because it completely anonymizes the transaction trail, and it prevents, even a potential regulation enforcement. So I think the most potent tool currently would be more individual enforcements against influencers, and if possible their endorsers or developers, anyone who is involved.
Okay, thank you very much. I'm going to open the floor to our audience. If anybody has a question, you can please type it into the chat, or you can unmute yourself and ask directly. So I'm just going to leave it for a couple of seconds if anybody wants to take this opportunity to ask a question. If not, I still have a couple of questions left. We have about 4 minutes till the end of the event. So I'll just see if anybody wants to ask. If we don't have a question right now, I just wanted to quickly ask Olivia about, in your article, you specifically focus on copyright as way of protecting AR, VR, and you have mentioned the possibility of using trade secrets, especially when it comes to the underlying technology of this medium. Is there any other kind of right that might be more suitable to offer creators and authors sort of sufficient legal certainty and security when it comes to this this new medium? Or is this going to be a task for copyright as it sort of develops?
I think certainly to a great extent it's going to be a task for copyright as it develops, but the way that we're seeing art in virtual environments being used, we can already see that we're going to need a significant amount of designs, protection, especially when we're having these fashion shows within the metaverse or like within Decentraland and things like that. Trade secrets, absolutely, for protecting that technological advancement. I think particularly where you're creating something that's very unique visually with that underlying code, that's going to be a huge thing people are going to want to protect. And certainly just beyond moral rights, these creators are going to want to make money from their creations. So that's going to offer new challenges. I think we're seeing a trend these days that people are like no longer uncaring about sort of the legacy that their work's going to leave behind. They want to have permanence if possible, and at least they're going to want that permanence whether in digital space or the physical space.
And I think that is even more so true where our lives are becoming much more digitized, and perhaps we are starting to think more thoroughly about the kind of digital footprint we are leaving behind and our ability to control it, and perhaps share it or ensure that the sort of digital legacy that we are leaving behind is the kind of legacy that we want. And I have another really quick question for Zoe, and we will be able to wrap this up tonight. I know that the issue of deceptive advertising, or the rather the relationship of trust that you've mentioned between influencers and the audiences, can have a sort of negative side effect where we see practices like deceptive advertising or gambling, and this to some extent can link to mental health issues. So something that we've mentioned in, or we focus on in the editorial, but I also do see a possible connection to your topic. Do you think that the impact of that relationship of trust, and when it's misused by influencers, can impact on this as well, on well-being and mental health?
Definitely. I think this is a very interesting point, especially having been through lockdown after lockdown for the past 2 years. And a lot of people, including myself, have relied a lot on consuming content to get over whether they in quarantine, for example, or not. And it's really interesting to see how, even for example, with the case I'm discussing in the article, no one ever doubted the influencers at hand for being deceitful. And even when the news broke out, a lot of their audience tried to support them and defend them and try to prove that this is not the way it is and it's a mistake. And you really see that a lot of people feel the betrayal, and it really is expected to some extent. A lot of people that maybe are not in the industry or have not been in the place of being an audience after a long time do not understand this, or may find this absurd on how you can develop such a relationship with someone you don't know. But I think it is very much a real issue, and a lot of people can be affected. And you see that because after scandals break out, you see that a lot of people do class action lawsuits, and involves minors, and it's a really sad thing to see the industry being tarnished by practices such as deceptive advertising, and having real people feeling betrayed, and even after having lost money and having been frauded, essentially.
Thank you so much. This is the end of our event tonight. That was the last question that I had for you. Thank you very much for all of you to coming tonight and sharing your insights and your experience and your expertise with us and with our audience. And I do hope that you will stay in the interactive entertainment community and network, and your work will further contribute to making positive changes throughout. Thank you so much. Thanks everybody for coming, and we'll see you at the next event. Thank you. Good night.